Hi, good evening, everyone. I'm Jen Mildren. I'm the Pro Bono Coordinator for Legal Aid Service of Collier County. Thank you for joining this webinar, and this webinar is being presented in honor of Pro Bono Week. Generally, for Pro Bono Week, legal aid would be out in the community. We'd be hosting clinics. We'd be doing these types of presentations in person. But like all of you, we have had to adjust to the change with the pandemic. We're all employees, right? So we thought this was a really, really important topic to talk about. So that's why we're doing this tonight, and we're doing it at 6:30 p.m. in the evening, hoping that we can get as many of you to join us. But after a long day, we understand that's sometimes not possible. So this will be recorded so that you can view it later. And hopefully we have had enough participants and addressed all of your questions. So before I turn it over to our expert, I'm just going to go through some housekeeping issues. The webinar here is designed to answer your questions. You can use the hand raise button on the bottom or side of your screen, depending on which type of media you're using. So at that point, then your microphone will be unmuted and you can ask your question. Alternatively, you can type your question in the chat function and I'll ask it for you. If you're having any technical issues, please refer to the slide in front of you, which has my email address as well as our development director, Melina. You can contact either of us via email. We have our email up on our screens right now, and we'll be able to help you either get back into the webinar or ask your question. So please allow me to introduce Benjamin Yormak. He is a board certified expert in labor and employment law. He's also a frequent lecturer on a variety of labor and employment law topics. He's devoted a significant part of his practice on whistleblower cases and cases involving fraud against the government. From 2016 until 2019, he's been recognized by Super Lawyers magazine as a rising star. This is an honor bestowed upon only the top 2% of Florida attorneys, as voted by their peers. He has also been selected by his Southwest Florida peers as a Naples Illustrated top lawyer and has won the AVA Clinic Client Choice Award. Further, he's been recognized as a National Lawyer of Distinction and has received superb 10 out of 10 client ratings on AVA. He previously worked with the United States Department of Justice and Maine Volunteer Lawyer Project while in law school, and also has received the Pro Bono Service Award. As I mentioned before, this webinar is being brought to you in recognition of Celebrate Pro Bono Week. And without our pro bono attorneys, legal aid would not be able to service all of the people that we are able to do. So we really appreciate our attorneys that are willing to step up and do this kind of thing. As you can see, you're in really good hands with Ben, and he's ready to answer your questions. So before we get started, I'll let Ben kind of give an overview and we'll get right to your questions.
Great, Jen, thank you for the gracious introduction. Labor and employment law in Florida is just such an interesting topic that does not get nearly enough attention, yet it's something that we hear questions about constantly. What are my rights? Can my employer do this? Am I allowed to do that? These are questions that there are not a lot of people around to answer employee questions, unfortunately. And obviously the elephant in the room with this presentation is, of course, COVID and how that has really changed things from doing webinars just like this rather than being out in person to working virtually as now the norm. It has radically altered how we view the American workplace and also has really revolutionized certain industries while pushing others to the brink. We don't need to look much further than many entertainment venues, tourist places, movie theaters may never fully recover. So the impact of Corona has been profound. We have certainly seen more severance agreements in roughly the 6-7 months of Corona than we typically would see in about 5 years, which is not great as an indicator of how our economy is doing. The impacts of the coronavirus are going to be felt for years to come. And as we say this now, and this presentation is being given October 28th, we're looks like we're entering a second wave. So things could get a little bumpy yet again, even though some businesses have opened and Governor DeSantis has opened the state. Fortunately, there are employment laws that are in place that do offer protection. I just want to touch on a number of them as it relates more specifically to issues about COVID. First of all, the Family Medical Leave Act has always been known mostly for maternity leave, but it is also there to care for your serious health condition or that of a close family member or loved one. And that applies where an employee has been there for more than a year, worked more than 1,250 hours, and the employer has 50 or more employees. But after the coronavirus came to be, Congress actually enacted some expansions. And the expansions are often misunderstood. People sometimes don't even know they exist. Other times they think they exist far too broadly. Hopefully I can provide a little bit of clarity on it. The most important one to remember is the extension of the Family and Medical Leave Act. All right, it did a number of important things. You're covered if you have been employed for 30 days, and then you're entitled to up to 12 weeks of FMLA for a covered reason. An additional covered reason, however, under the expanded Family Medical Leave Act, is to care for a child who's under 18 whose school or childcare is closed due to COVID. So that affords much broader protection than what had ever existed under the regular FMLA. And typically, where we've had schools being completely closed, that was a godsend to so many parents who are now able to say, at least my job is protected. Now, the law is still in a bit of a state of flux because it has not been greatly tested in the courts. There are questions about whether you can actually sue your employer, but the general consensus so far has been, yes, you are, as an employee, able to sue your employer if they either don't give you this leave or if you are not reinstated when you're ready to come back. Now, the act will expire at the end of the year unless Congress changes it and extends the law. So there's an up and a down associated with it. Certainly the biggest down is that it doesn't cover you for any other reason other than childcare. So folks without children are out of luck. Now, what does this mean when we are dealing with employees who are either older or who are suffering from health conditions that may make them more susceptible to COVID? Well, fortunately, the Americans with Disabilities Act also exists. That applies where the employer has 15 or more employees. And also, we would look to OSHA laws, which require an employer to provide a reasonably safe workplace. And of course, that's on a sliding scale. Some occupations are inherently more dangerous than others. Under any of these, though, an employee can kind of craft a basis to not have to work if they are going to be at risk. So you can imagine, however, a nurse, an essential job function is going to be to perhaps care for COVID patients. If they have serious health conditions that prevent them from doing that, they may not be able to perform the essential function of the job, and thus they could be terminated as a result. Same thing with OSHA applies. If dealing with COVID patients is an inherent risk of the job, you may not be able to do much other than just return to your job. The number one question we get as COVID has happened, I'm in an office. Social distancing isn't really possible. What can we do? Those are tough tough questions. Each of these kinds of situations is all fact and industry intensive. You have to figure out what's reasonable within the industry and within that particular office space. So there is not, unfortunately, a simple catch-all, where I could say the employer can do this, but they cannot do that. Certainly, they cannot group everybody, like cattle in close proximity and expect that that's going to pass muster under OSHA. So there are a lot of different fact patterns. There's a lot of different questions that come up, not just with COVID. The employment law in Florida has many very interesting kinds of facts and law. And despite it being maybe a little bit academic, my colleagues would used to joke with me and say, well, Ben, all you do is crunch overtime numbers all day. How boring is that? And I would quickly remind them, I see the underbelly of the American workforce and the American workplace. So we know what really goes on, and it is far from boring. So because this is a question and answer session, certainly I'd turn it over for any questions that might be from the audience and or Jen.
Thanks, Ben. One of the questions that's already come in, very relevant, and also one of the hardest parts I think that we've seen since COVID has started in March of 2019 is, what are my rights if I work and my employer goes out of business suddenly and they don't, or they just can't pay my wages?
Boy, the law is always slow to react. Is usually very slow to keep up. If the employer goes out of business, your rights are limited. I wish I had a better answer that other than you may be out of luck. Now, if there is, and if you just haven't been paid, meaning if you've done the work but have not been paid for the hours that you've put in, that's likely going to give rise to a minimum wage claim, either under Florida's Minimum Wage Act, which has a higher prevailing minimum wage, or a federal minimum wage claim under the Fair Labor Standards Act, which has a lesser hourly wage. If you have not been paid anything for hours that you've worked, you could potentially bring an action not only against the company itself, but the FLSA, for example, makes clear there could be individual liability for the owners or operators of the business who refused to pay. So there is a potential remedy, provided that those owners individually have sufficient assets or money to pay a minimum wage claim. Now, if they haven't paid minimum wages, you're not only entitled to your unpaid minimum wage, but generally you're entitled to double damages, what we would call liquidated damages, and your attorney's fees. And the reason that attorney's fees were drafted into this statute is good public policy, because what employee is going to sue their former employer over perhaps a $200 unpaid minimum wage claim? Well, the filing fee alone is $400. So you would lose money by going after the action, and it would allow the employer to essentially avoid paying minimum wage and treating the employee unfairly without any kind of consequence. So the law was drafted to prevent that. If the business no longer exists and that person does not have, the individual does not have assets, generally there's nothing to collect. It goes right into the old adage, you can't get blood from a stone.
Mm-hmm. Okay. Okay, so this one has come in a couple times from in various forms, and I think it's really important. If I say that I have a disability that puts me at risk of severe illness if I get COVID, is remote work agreement a reasonable accommodation? Should my employer have to allow me to do that?
Boy, we've seen remote working now become the norm, and I think pre-COVID, the general rule of thumb with most federal judges for sure who encounter these claims more, they would generally say that attendance at the office is an essential job function. There are a number of different cases that say that. And, for the longest time, that made perfect sense. The American workplace, you show up at the office like everybody else. Why do you get treated different? Well, then there's COVID. Now what? So what employers had to do was adapt and adapt quickly. And what they ended up doing was saying, okay, well, how can we use technology to its maximum so that we can continue to operate and survive while not, obviously becoming a super spreader haven because we have everybody in the same office. Enter the remote workforce. Certainly, lawyers, we've adjusted, and I think the both lawyers and the judiciary alike have done an absolutely tremendous job of adapting. Many other workplaces, however, have not done quite as good a job. If the job can be done remotely, it is still likely a reasonable accommodation to allow that, particularly where somebody is susceptible to, if they contract COVID, it could become fatal, as opposed to, somebody else who maybe doesn't have the same risk factors. So it's all a case by case basis. It would be both a request for a reasonable accommodation under the Americans with Disabilities Act, in addition to a possible objection to being forced to come into an unsafe workplace under OSHA. Now, the advice that I would give any employee is to make sure that they make their request clearly in writing and state why. They should also be prepared to have medical documentation supporting that request, because the employer can ask for some a doctor to sign off on it, for example. Otherwise, the law could just be abused. So there's a bit of a balancing act that has to happen, but it's really a low bar for an employee. And if the employer is still refusing, at that point, the employee may have legal recourse under both the Americans with Disabilities Act and the Florida Civil Rights Act. The Florida Civil Rights Act has a disability discrimination provision, just like the federal act does.
So has there been any case law addressing this very issue yet, or is it too soon for that?
So it's a little bit too soon, but what we are starting to see are many more COVID cases. And I don't mean COVID positive cases. I mean,
right.
Bubbling up through the court system. Then what we are seeing probably the most right now, we're seeing a ton of failure to reinstate and rehire, right?
Okay.
So March and April was like furlough central. Everyone's either getting furloughed or laid off. And it came at a particularly bad time for us down here because we're leaving season. We're, particularly the seasonal workers, they're going to get laid off or have downturns anyway. Mm-hmm. Well, you go from a business that will struggle in the summer to being shuttered in the summer. Mm-hmm. Well, now what happens when that business reopens? We are seeing a lot of businesses where they're bringing people back, but only bringing certain people back.
Mm-hmm. That's interesting.
Oh, you're older. You're not in the best of health. Yeah, we don't need you yet. So we're seeing a lot of that. A lot of just we'll call you. Well, the other one, of course, is if somebody has taken medical leave or has needed childcare leave. Same kind of thing. Basically, anything that would give the employer the impression that this person may either need leave or can't be fully depended on. That's the kind of stuff that we're seeing a lot of. And we get a ton of phone calls daily.
Is that discrimination?
The same thing.
Is that discrimination? Should we be asking those questions?
It would be discrimination. Now, the test is really, have you applied or reapplied for your job or made other attempts to come back? We're seeing more of this where the employee is part of like a work group. Mm-hmm. Like there's 5 people in the work group, 4 out of the 5 come back. The one person not back is, say, 65 years old.
Okay.
They're starting to say, well, you brought my whole work group back. What the heck? Or when they're telling people, oh yeah, we're just not filling your position. And then they go on, Indeed.com or Monster Career Builder. There's their job. So we generally
Interesting.
tell people to make a written request to be reinstated.
Mhm.
Um, Certainly the employer then is going to have a heightened responsibility to articulate a legitimate business reason why they're not rehiring or bringing that person back. And the key is a legitimate business reason. I don't wanna doesn't cut it. We see often too, there's all kinds of urban legends in employment law. I can't tell you how many times somebody will come in my office and tell me one of them, and I say, "Oh gosh, haven't heard that one today." Um, and one of them on the on the employer side is Florida's an at-will state. You can be fired for any reason or no reason. And then they take that a little too seriously. Like, we don't have to give you a reason as to why we're discriminating against you. The heck you don't. You better be
Right.
able to, because if that employee challenges the denial of reinstatement or other reemployment, the burden then is on the employer to proffer a legitimate reason why that person was not rehired. And you can't just say because Florida's an at-will state. You got to, the courts demand a little bit more than that. You could say the position was eliminated. You could say the person had, work deficiencies, and so we opted not to bring them back. But you have to be able to prove why. It's not, like I said, it's not sufficient just to come to some conclusion. Um, that's why the employee should really be paying attention and saying, why am I not being brought back? I couldn't help but notice my job's listed on, Career Builder. Please reinstate me. I'm ready to come back. That really puts the employer in a real pickle. It really does. There's not much that can be done other than, I guess you're showing up to work on Monday morning.
Yeah. That's really good information because I myself have, being fairly new to Florida, didn't know that. Now, circling back to, you talked about the Family Leave Act. Another question came in. Someone says, I don't want to send my kids back to school during the pandemic. So can I use the Family Leave Act to take time off? And can I keep my job? Or what can I do, especially since I can't work from home?
That's a really good question. And I think that because of the uncertainty that we're seeing in COVID, and I mean, uncertainty is perhaps being kind. The viewpoints on this have become so politicized, I can't even believe it. But it's personal choice at this point whether parents return their children to school. If they do not have alternate childcare, the extended FMLA should still apply. Candidly, hasn't been tested.
Okay.
So this, if you want to become a test case, maybe this is the right one, but this is an area where we can't give really, really clear advice. And my colleagues that represent management and the employer say the same thing, that it's sometimes this was changing at some points by the day. Somebody
Mhm.
would call me on a Monday, I'd give advice, and then by Tuesday I'd call them back and say, everything I told you yesterday has changed. Department of Labor has a new regulation or new guidance or an opinion letter, and it was really changing the game. But I think the rule of thumb is still the same. If you do not have adequate childcare as a result of the coronavirus, the extended FMLA should still provide you job protection.
And is that typically paid or unpaid? Because I know the CARES Act was providing some pay, but to a
Yeah,
certain extent.
it's kind of, it's a little bit all over the map. It really is. We're seeing, at least a couple of courts have said there is no private remedy if if your employer decides, well, we don't want to pay you. But under the extended FMLA, yes, it is supposed to provide some pay. And one point that I want to make clear, um, the act only applies to employers with fewer than 500 employees. Fewer than 500. So your big box stores, Publix, not covered by this. And as I have mentioned to many a person, if that upsets you, vote, because Congress enacted this law. There's an exemption for large businesses. To me, that seems a little bit backwards. This puts all the pressure on small and medium businesses and completely exempts big business. And big business has never been exempted like this before. The FMLA, as it applies normally, applies to businesses with 50 or more employees without any ceiling. So folks need to be aware, if it's a large employer, this act may not actually cover them. Now, if you are covered, the first 10 days of the leave are unpaid. The employer can require you to use other PTO. So any of your paid time off, they can require you to burn that. And then after that, you're entitled to 2/3 of your regular pay for the remainder of the leave, but the pay is capped at $200 per day and $10,000 in the aggregate.
Okay.
Okay. So for somebody who's, maybe making, $75,000 a year thinks, well, this is great. I'll keep my kids home and everything should work well. No, not so. You are going to have that cap that comes in there.
Okay. Good deal. Here's one about returning to work. Mm-hmm. So there's actually two parts to this. First of all, are local mask requirements voluntary? And what happens if my employer doesn't actually follow the rules about masks? What should I do?
Yeah, we've been getting this question a ton, particularly in Collier County, where there is a mask ordinance that's in effect. It's a tough answer because I can't craft a catch-all. It is, business specific. You can imagine landscapers who are outside probably, wearing a mask isn't as much of an issue as 15 people all in a conference room, for example. I think, again, this gets back to an individualized inquiry. Do you as an employee have any health conditions that would otherwise, preclude you from being present in such a situation? But also, too, is what's your employer doing? Are they providing a safe workplace? Are they demanding that you sit in on, a staff meeting where they pile 20 people in a fairly small conference room? Is it for a longer period of time? I think that employees are certainly within their rights to say, whoa, And, I don't think you need to look actually much further than the scandal that's brewing in Major League Baseball, stemming from last night's World Series win, where the Dodgers third baseman tested positive and they removed him in the middle of the game when the test result came. And then Dodgers win the World Series, but there he is out on the field, in a pig pile, taking photos.
Everyone saw that.
Yeah. And, I get the excitement of the moment. It could be a once in a lifetime thing, but what are we thinking? You've got somebody who's COVID positive, who's jumping into a pile of, 20 plus other guys celebrating, exuberant. Like this just does not seem like a smart move, but it's something that we've seen with employers where, somebody maybe has COVID symptoms, but hasn't received a positive test yet. And they let them work out the rest of the shift, for example. Mm-hmm. We've seen a lot of that kind of stuff where healthy employees will say, what is going on? Why am I being forced to work? And Jimmy over here is, hacking his lungs out with a fever. Like, this doesn't seem to be safe. And again, I think this is where OSHA kicks in to say, no, that is not a reasonably safe workplace. And this employer is not acting in a prudent manner.
Okay. So laws that we already have in effect kick in based on the environment of the workplace. So another person said, I have a fever and my employer checks our temperatures because of COVID. And one day they sent me home, but I don't have any more vacation or sick time. What am I supposed to do?
Go home and be glad you have a job the next day if you're lucky. Recent guidance from the Equal Employment Opportunity Commission um, they changed their course on temperature checks and whatnot in the wake of a COVID pandemic. Typically, asking health questions, temperature checks, that kind of thing, were out of bounds based upon the Americans with Disabilities Act. However, in light of the pandemic and OSHA laws requiring that kind of balancing of interests, the EEOC's guidance said, yeah, that's not a problem to do. The employer has the right to send you home. Heck, they could send you home just because they said, I don't like someone who's wearing a red shirt today. There's not much you can do. And if you don't have any paid time off, they can send you home without any kind of requirement to pay you for that day, as a general rule of thumb. So you don't have a ton of rights when it comes to this. And certainly we've seen a bunch of those kinds of questions. What happens when the employer says, we're going to require you to quarantine for 14 days? That's where it gets really interesting, because if the employee comes and gets a COVID test that's negative, that employer should be letting them back. Okay. And if they don't, then they could be potentially violating the ADA by virtue of it being a perceived disability.
Okay.
So if the employee provides sufficient documentation showing, I'm fine, I'm not a threat to myself, I'm not a threat to the workplace at all or the customers, that should suffice. Obviously absent that employee coming in, hacking along and, some other symptom that would be, worrisome.
Right. Well, we all know that we can have fevers for multiple reasons, so.
Absolutely. And I think the medical science that's emerging right now is showing fever is just one possible symptom. By no means is that, the litmus test that you do or do not have COVID. I've known people that have had COVID and didn't have a single symptom. No fever, no headache, sore throat, no cough, nothing. So it's a very dynamic disease. We are still learning, and employment is trying its best to adapt.
Okay. So kind of a switch gear here. Somebody has asked, what are my options to negotiate a reduction for severance agreement payment due to COVID-based illness, with me being a prior class action member that received settlement from the employer for FMLA parental leave discriminatory practice?
Yeah, interesting question. We've been seeing a bunch of these. Like I said, we've been reviewing just an absolute ton of severance agreements in the past few months, and many times one of these employees that we meet with says, I have a legal claim. What's the effect of signing a severance agreement? Well, signing a severance agreement is almost always a complete waiver of any rights you may have to sue your employer for any reason at all. So if you sign it, you're going in eyes wide open that you're releasing that employer in exchange for whatever amount of money is being offered. However, it gets complicated where the employee has legal claims, but there is a possible bona fide reduction in force. We've seen no more legitimate business reason than we are almost, out of business. We have to lay off employees. I mean, you can just look at the number of high profile bankruptcies that we've seen in addition to the high profile layoffs. Disney, tens of thousands, Hertz, tens of thousands. I mean, just an absolute ton. But in order to negotiate more money into your personal severance agreement that is being offered to the employee, you're going to have to show that you are being treated differently somehow than everybody else is. the best way to get more money in a severance or to challenge the separation is to prove that it's not really a reduction in force, or that you were arbitrarily selected to be in it where otherwise you wouldn't. So generally, you have to be given what the criteria is and then what the ages are of the affected people. We had one come in just literally just the other day where it was, kind of a big box store. There are layoffs. Admittedly, there are a couple store closings, but the only manager let go happened to have a pending EEOC charge of discrimination. How does that work? And so that's a prime example of where you would go to the employer, either through an attorney like myself or individually, to say, this is kind of garbage. Why am I being discriminated against here? I can't help but notice the coincidence, only manager, only person with a charge, and I don't meet all the other criteria for the layoff, or, somebody else meets it more. Like seniority is an easy one, right? Somebody's been there 10 years, but Jimmy got hired, 2 months before COVID, but he kept his job. I'm fired. Why is that? That's indicia that there's discrimination or retaliation that's going on. It's just a real challenge these days to look at a reduction in force, because so many businesses are indeed reducing employees. But the most common claim that we're seeing here is when certain people are getting kind of thrown into the pot of people that are being let go. That's a really tough claim to prove, because you have to show not that there wasn't a real reduction in force, but that that person was being treated differently because of some protected factor. So those are challenging ones, but we're seeing that kind of a claim more and more.
Good deal. Okay, kind of circling back to reopening, because I feel like that's really where we are right now in the U.S., at least in Florida. Maybe backtracking a little bit throughout the rest of the United States, but someone said that my employer did not notify us that a coworker had tested positive for COVID, and I feel that we should have all been quarantined after that positive test. What should I do?
The public's kind of question, where you've got a large workforce. What do you do? Mm-hmm. This is a tough one for employers. Me representing workers for a living, I oftentimes get accused of not having a lot of sympathy for employers, but that's just not true. This is the kind of question that puts employers in a tough spot. What do you do? Because on the one hand, they are obligated to protect an employee's HIPAA rights, where that employee has shared, protected health information for the purposes of, say, taking leave under the FMLA or the ADA or workers' comp or something like that. So that employee has rights, and we've actually prevailed in a case where we challenged whether or not that's a violation of the ADA and FMLA, meaning where the employer spills the beans to other people about the health condition. So we've been on the other side of that issue, and we've won. And so that actually puts the employer in a really tough spot where an employee tests positive for COVID. What the heck do you do? Well, you can't name them by name, that's for sure.
Right.
You can't say, well, Bob over in accounting, tested positive, so you all should treat Bob like a pariah.
Right.
That's really what happens, right? I mean, if you name the name, people start doing their own, rudimentary contact tracing to try to figure out what the heck has happened here. And it doesn't usually work all that well. The upshot is usually the poor employee who got sick becomes persona non grata real fast. What should the employer do? I think that under prevailing law, they're going to have a duty to at least advise people that they may have been affected. They may have come into contact. The employer should absolutely not be naming names. The employer should, try to keep that confidentiality as best they can. But they could say, for example, an employee in the accounting department was sent home due to a positive COVID test. Anybody that would like to take time off to get tested or otherwise quarantine, please contact human resources, to make that kind of an arrangement.
What about in schools? Because I know they're sending handfuls of students home at a time for quarantine when they've been around a student, more than 15 minutes in a day. And parents are saying, hey, what am I supposed to do for these 2 weeks that all of a sudden my kid is at home now having to do distance learning?
Yeah. So again, the EFMLA should kick in at that point if covered,
Okay.
and provide that short-term, preservation of employment. But it creates a problem, certainly. Teachers, for example, God love them these days. They had to put up with a lot before, but 2020 is really, really challenged educators. And I think if there is one silver lining out of this that we're seeing is, so far, knock on wood, we're not seeing a ton of cases from high school and below. Thank God for that, because otherwise, you're putting these kids in a confined space. You can social distance as best you can, but you still got 15 kids jammed into one classroom. All it takes is one.
Right.
But so far so good. And I think that's where the medical science has a real question mark as to why the heck kids are just not as effective, and why are they not spreading it? I mean, I have 2 kids, and I joke that we send them to school, otherwise known as the human petri dish.
Right.
They bring home anything known to man.
Yeah.
And of course, they'll be cured in a day or two, and my poor wife and I get dropped like a ton of bricks. And this is just the opposite.
They're sure spreading the flu, so why not COVID? That is interesting.
It is interesting, but when we have teachers, for example, I think the good thing is there's always substitutes ready to come in. So there is a labor force that's there. Private business has been reacting, maybe to put it diplomatically, not as well, because they rely on certain employees. Maybe they're not key employees, but they're important, and they don't have somebody to tap on and say, you're in, get in there. You're filling in for Susie today. They don't have that. And so, that's where we're seeing a lot of these employment disputes brewing.
Okay. So one last question, and I'm going to move on to, there's a couple questions about unemployment that maybe you can answer, but someone asked, upon reopening, is my employer allowed to single out certain employees for screening or testing?
That's a good question. I think that the answer is going to be that the employer has to have some kind of a reasonable suspicion. I mean, if you're working, for example, in a restaurant, and one of the servers is coughing, and the hostess says, hey boss, they're really coughing, is it reasonable to have that person sent home for a test? Absolutely. I mean, we're in a pandemic era. This is not, oh, you may have the flu. Right. This is a different ball game, and COVID really has changed the game. It's some people try to pretend like there's just nothing all that different. We should just be business as usual. Well, that's great, but it's not practical right now. And that's a prime example of it. So the employer can, I think, send people home, particularly for testing and that kind of thing, so long as they're not doing it in a discriminatory manner. If you're sending every Hispanic worker home to get tested, that's not going to fly. If you're, focusing in on older workers, same thing. Can you do it across the board for everybody? Sure. But the old adage, what's good for the goose is good for the gander, has to apply. You have to have, equality amongst those kinds of policies as an employer, or else you're going to risk, either a charge of discrimination or a full-blown lawsuit.
One more question in that regard. Somebody wants to know what happens if they refuse to submit to a temperature check. Do they have any rights?
Uh, the right to find another job is probably the the closest
All right.
answer. Um, yeah, as long as the temperature check isn't, again, to what my last answer was, as long as it's not being applied in some kind of discriminatory manner. I mean, if there's a reasonable suspicion and you say, hey, boss, I'm not doing it, I think that the employer is going to have every right to say, then you don't work here because we're not having somebody come in our workforce that isn't safe, that's going to be a threat to others. Um, under the ADA law, there's a defense to ADA claims called direct threat. Most often, you see this where somebody's mentally unstable, worried about, you know, maybe shooting the place up, or maybe they work heavy machinery and their doctor's prescribing heavy narcotics. Okay. That's an example of like a direct threat where the employer's like, yeah, I get that you've got this disability, but I don't really want you operating the crane that goes 20 stories up when you're on oxys.
Yeah.
That doesn't seem safe to anybody. So that's an example of, yeah, we've got a disability. Yeah, you might be able to perform the essential functions of your job, but I'm not sure you can do it safely. That's one where the employer gets to discriminate based on a direct threat. That same kind of thing would apply here, in my opinion, with COVID, because the person that may have COVID could spread it to others, thus posing a direct threat to the workforce or the customers.
Yep, that makes sense. Thanks for that. So I've had a couple questions about unemployment, and so I'm just going to kind of try to condense them. So one person wants to know if you have any insight into why it takes so long to receive the money, and why don't they ever call me back when I try to get a hold of them?
Well, let me tell you, you're not alone. Okay. When the only agency that may actually be more frustrating than Florida unemployment could be the federal VA. Okay. That may be about it. But we run into the same thing. I mean, we handle unemployment hearings all the time when somebody has been denied. And just even basic things, trying to, get documents submitted, figure out when a hearing is. We can't get somebody to pick up the phone. That's before COVID. Post COVID, forget about it. It is not. It is not even close. It is, to say it is frustrating, maybe an understatement. And I'm not the one who needs the money the most because I'm not the one applying for the benefits. This has been so widely reported. A couple of my colleagues in Northern Florida had filed, legal action over just what an absolute debacle Florida's unemployment was. Those of us that practice in the area could have told everybody this pre-COVID. COVID just brought it to the forefront because now for the first time you had tens of thousands of people not getting their money, not having claims processed. In fairness to unemployment, these were unprecedented times. But to put this into perspective, that's not the issue. They had problems from the get-go. So this just pushed it over the top.
Okay, and there was one more unemployment question. I think this is just asking for sort of an update on the Florida rules and unemployment. Do I still have to file weekly? Do I still have to show that I've been looking for work each week, or is there still a moratorium on that?
It's a good question. That's one that, quite frankly, I'd have to do a little bit of digging on to see what the current state is. But my best guess at this juncture would be that because Governor DeSantis has reopened the state, and meaning all businesses would also be reopened, I think that unemployment would likely be following suit and requiring the usual 5 job searches per week. I would also say, too, it's a very low bar. Our general advice to clients in the modern day and age, gone are the days of having to buy a newspaper and, going to the classified sections and, cutting out, what job postings look good. Sign up on Career Builder, Monster, Indeed. Heck, they will send to your email inbox most mornings a summary of the jobs that you may be qualified for. Then all you have to do to qualify for unemployment is apply to 5 of them in a week. It's a tremendously low bar. Still amazes me. Some of my clients can't always hit it, but
well, true. It is tedious to get onto the website, though, as some of our
It
viewers have
is.
pointed
It is.
out.
They
So,
are trying to straighten that stuff out. But really, the problem occurred before COVID. It wasn't a good
right,
system before COVID.
right, right. Well, hopefully COVID maybe helped in that one thing throughout
Hmm.
the state of Florida, improving the unemployment website.
Yes.
Okay, well, we are almost at an hour. And so I'm just wondering, like, how many urban legends did we cover? Like, what else do you think is worthy for people to know that are navigating
Sure.
employment?
Sure. There are three that are my favorite. The first one is that at will, I can fire anybody for any reason or no reason. But my next two rank, one and two in this whole thing. My favorite one has to be when somebody comes into my office, tells me, I have this non-compete, but I just want you to take a quick look at it. I mean, I know non-competes aren't enforceable in Florida. I usually say, oh gosh, that's news to me because they sure as hell are. Um, and I don't know where that urban legend comes from, but I hear it a lot. So to be clear for everybody, non-competes are absolutely enforced in the state of Florida. In fact, Florida is one of the toughest states for employees. They get enforced all the time. So I don't know who started this rumor, but I'd love to talk to them and straighten them out at the source. The other favorite one that I have is in almost every settlement agreement or severance agreement that comes through my office, we negotiate in what's called a neutral job reference provision. Essentially, that means that the employer would only be able to tell a future employer dates of employment, rates of pay, position held, nothing else. That means that the employer wouldn't be able to answer whether or not that person's eligible for rehire, right? I get people all the time that tell me, Ben, thanks very much, but I don't think that matters. I know it's illegal for them to give me a bad reference anyway. And I kind of go, really? You think it's illegal for your former employer to give you a bad job reference? Where'd you hear that from? Well, and I never get a clear answer. So again, yes, your former employer can trash you. And as long as it's opinion or truth, there is not a heck of a lot that you can do. It's tough.
Does that just depend on the company's policy, though? Because I had always heard, might be also an urban legend, that if they didn't have anything positive to say, they could just say, yes, they worked here. And that's all they could say. So,
Yeah, we're seeing more and more employers going to that kind of a neutral reference policy anyway. Many of the big Fortune 500s just as a policy say, call the work number. And that's all that's given out is that kind of tombstone basic kind of information. Where we see these kinds of claims, almost always the smaller, sometimes medium-sized businesses, usually where the employee's departure was not amicable. That's where we see it the most, where there's still bad blood between them, and that former employer then goes out of their way to trash them. If they go out of their way, there may be a claim. But if that employer says, no, my former employee, yeah, they're not eligible for rehire. They're not eligible for rehire. I mean, that's fair comment. You might not like it, but they're entitled to have that opinion and to note that in your personnel file. The other thing that I hear a fair bit, and I'll leave the urban legend theme on this one, is that they have a legal right to give me my personnel file. Now, I have a lot more tolerance for this urban legend because some states that is the law, that the employer does have to produce a copy of your personnel file. If you work for a private employer in Florida, not so. That personnel file is property of your employer, period. There's very limited information your private employer is required to give out.
Okay. All right. I don't see any further questions, and we are at the hour. Thank you so much. We so appreciate it. Again, part of the work that legal aid does would not be possible without the attorneys in the community that help us with fill the gap for some of the cases that we're just not able to take in-house. And this is why we celebrate pro bono attorneys and we celebrate Pro Bono Week. So thank you for tuning in. Again, like I said, this will be up on YouTube and Facebook, and so you can reference it at your leisure. And if you ever have any questions or concerns, please feel free to reach out to us at Legal Aid. And Benjamin, this was amazing. Thank you so much.
My pleasure.
Everyone have a great night. Thank you.